and thank you for joining us for another episode of I'll Allow It Nevada, your go-to podcast for insightful glimpses into the Nevada judiciary. I'm your host, Seth Beasley, representing the Supreme Court of Nevada Administrative Office of the Courts. On this episode, we're going to be diving into the 2nd Judicial District Competency Court. To guide us through this conversation, I am delighted to welcome Judge Egan Walker of the 2nd Judicial District. Judge Walker presides over Competency Court and is going to help us understand this court's crucial work. Thank you very much for joining me on the show, Judge Walker.
Great privilege to be here. Thank you for having me.
For starters, perhaps you can give us a bit of an overview of Competency Court. What is its mission and why was it started in the first place?
Sure. I apologize for what's going to be a fairly long introduction, Seth, but really we need to dive into why is Competency Court necessary? And so for all of our listeners, especially those with legal training, I know you'll understand that in order to answer criminal allegations, every person accused of a crime has to be competent to answer those allegations. In the words of Dusky versus United States, the individual has to have a rational understanding of the process of court, of the factual allegations against them, and ability to aid and assist counsel in the prosecution of their case against them. And that overall standard applies in the context of a nationwide mental health emergency. Certainly during COVID and since COVID, but even before COVID, the American Academy of Pediatrics, for example, and other professional medical organizations had declared a mental health emergency in the United States. That certainly applies here in the West, particularly in Nevada, and particularly in Washoe County and the northern counties in Nevada, as really all over Nevada. And as a consequence of that mental health crisis, our criminal justice systems tend to be very full of persons with either acute or chronic mental health issues. And those issues can, on occasion, interfere with their competency, with their ability to answer the charges against them. We all know that, of course, you can have mental illness and still be competent, and you can be free from mental illness and not be competent to answer charges against you. So they're not a one-to-one correlation. But we have this mental health emergency, and unfortunately in the United States, for a lot of reasons historically, we don't have a mental health emergency net in most communities, certainly in communities in rural Nevada, but even in the large metropolitan areas in Nevada, we don't have adequate mental health resources. So all of that boils down to, as an example, at any time in the Washoe County Jail, north of 60 or 65% of the persons in custody in jail have to take psychotropic medications. And that speaks to the level and nature and pervasiveness of their mental health issues. And so as a consequence, we end up with this very busy criminal justice system that is very full of people who have mental health challenges, some of whom also have competency challenges. And so we stood up Competency Court here in the 2nd to address that crisis. We literally were in a crisis because the forensic treatment facilities in Nevada, Stein in the south and Lakes Crossing in the north, are both impacted. There's a waiting list for people to get into either or both of those facilities to be restored to competency. So the mission of Competency Court is really to address the burgeoning mental health crisis in the community, to decriminalize mental health, rather than using police officers and first responders and the jail as the mental health triage and treatment facility of choice in our community. We're instead trying to separate the wheat from the chaff, as it were. Identify those people whose mental illness is pervasive and consistent and who tend to cycle in and out of low-level criminal issues because they get captured by the criminal justice system when first responders are really responding to their mental health needs. And we're trying to separate those folks from folks who are accused of very serious felonies, rape, murder, robbery, et cetera, who need forensic restoration. So a long introduction, I'm sorry, but a good necessary introduction to understand why Competency Court is necessary. And the purpose is really to make sure we're applying the right service to the right people at the right time for the right reasons. If a person is accused of a very serious felony and there's a serious question about their competence to answer those allegations, they need forensic restoration services. If they are instead a person whose mental health or serious mental illness pervades their life and causes them to be captured many times for status offenses, loitering, trespassing, urinating in public, those folks shouldn't be in the criminal justice system and shouldn't be waiting to occupy beds at Lakes or Stein.
Okay, so for those listening and for my own knowledge, honestly, what is you referred to as forensic restoration or?
Correct. And so forensic restoration means the following. If I determine that a person is not competent to answer the allegations against them because they don't meet the basic criteria or the 3 Dusky factor criteria for competency, I can order that they be educated, that is, restored to competency. Frequently, the path for restoration to competency requires mental health treatment. Not always, but frequently. And so in order to give somebody psychotropic medications, for example, provide behavioral mental health treatment, those sorts of things, you need a forensic facility, a hospital-like facility. And because these are persons who are accused of crimes, they're most commonly in custody, meaning in the custody of the sheriff of the particular county where the charges are being lodged. And as a consequence, they need a hospital-like setting in a jail-like setting, or the crossover between the two. And so Lakes and Stein are the secure, either staff secure or physically secure forensic facilities we have in Nevada for people to be restored to competency, which again involves education, basic education about who are the players in court, what is the process of court, what are the rules of court, and then also addressing any of their mental health needs that interfere with their ability to communicate with their attorney or behave during the process.
Okay, so before diving in more into what the court does, perhaps some good background for our listeners. So the court's team includes a variety of different professionals. So what does the Competency Court's team look like, and how do they support the mission?
Well, the Competency Court team here in the second is a very large team.
Okay.
As an example, it has representatives of the district attorney, the public defender, the alternate public defender, any privately retained counsel who have clients who are enrolled in the Competency Court, myself, a court case manager, representatives from state agencies, for example, Northern Nevada Adult Mental Health Services, representatives from Lakes Crossing, representatives from the local CARES campus where a number of our clients live during either before, during, or after the competency restoration process, and any other, representatives of the Sheriff's Department and the Detention Services Unit in particular from the Sheriff's Department, and any other community stakeholders who really have resources to apply and information to give about the persons who are enrolled in Competency Court. Again, we exist in this system where we don't have enough beds to get people the treatment and education they need to restore to competency. And the result is they spend weeks or even months in a delay, in a kind of a limbo zone where they're in custody more often than not, where their rights have been interfered with because of the accusations against them. And they're in jail, if you will, or often waiting in jail to go to Lakes or Stein because we don't have enough beds. And so we need to make sure by application of this teamwork and team process that we're really using these limited resources for the people who need them the most. And it's a process of triage. It's a process of deflection or removal of people. I call it out of the pipeline from Lakes, or the pipeline to Lakes or Stein. And again, separating the wheat from the chaff, making sure that we're using these limited resources for the people most in need in the most serious cases.
I see. Okay. So what does a typical session of a competency court look like?
So it's evolved over time. We've been at this now approximately 2 years. It involves a court staffing and then a formal court session. Really, it involves meetings even before the staffing. So members of the team have sort of a pre-staffing meeting early in the week. We then have a formal staffing at 3:00 every Thursday, where for an hour we discuss the needs and circumstances of the human beings who are going to be heard on the calendar to begin at 4:00. That staffing involves talking about the person's mental health history, their criminal history, the current charges against them, whether or not, in light of the current charges against them, and after a conversation between the district attorney and the alleged victim in the case, whether or not those charges are appropriate for an alternative path, a path out of the pipeline. Interestingly, our statistics for the last year, really from October of 2023 until through December of 2024, reveal we had round numbers about 240 cases. Right out of the gate, of that number of 240 people, almost 50 people were, after being evaluated for competency, found to be competent and referred right back to the courts of origin.
Okay.
When a question of competency arises on a felony or gross misdemeanor, that issue is given to the district court judge who will be responsible for the case. In the second we decided, all of those cases would come to me so that we could have consistent handling and consistent case management. And so in each of the cases in Washoe County, where there's a gross misdemeanor or felony charge and competency is raised, this team triages those cases. We get people evaluated as quickly as we can possibly get them evaluated if an evaluation is warranted. If after the evaluation or even before the evaluation, it appears in the eyes of the district attorney that it's a case more appropriate for treatment rather than management through the criminal justice system, the district attorney makes a decision to find an alternative path. And so of those 240 cases, if about 50 of them were diverted out, almost half, 49% of the remaining 190 or so cases have gone on an alternative path in the last year, a path where rather than having the person remain in jail just to get a bed at Lakes or remain at Lakes while they're being restored to competency, a decision is made that we would provide treatment services to that person. So for example, mental health services at NAMS, hospitalization at Deanie Townsend Hospital if their level of mental health is so acute and so necessitous that they meet civil commitment criteria, or release from jail to the community, often to the CARES campus, for example, with supportive counseling at Northern Nevada Adult Mental Health Services and medications at NAMS. And so the staffing looks like an individualized conversation in about an average of 25 to 30 cases a week, where we talk about, is this person in the pipeline or not? Are they appropriate for an offline or an off-ramp away from the pipeline? Or should we just husband the resources we have and say this person needs to go to Lakes and needs to go to Lakes as quickly and expeditiously as we can get them?
Okay, so while we're on that topic of alternatives, and I know you went into a bit, but are there any more you can share about the alternatives to adjudication that the court explores?
So certainly, an example would be, as we've begun to pay attention, and I have to sort of drop a footnote here and say pay attention. What I mean by that is I've had the privilege of being involved in the adult criminal system in Northern Nevada since 1991, either as a prosecutor, a defense attorney, a private practitioner defense attorney, or a judge. And the traditional model in Northern Nevada I can speak to during my experience has been, if we think someone's crazy, quote unquote, notice I said crazy and not competent, because there are a lot of biases and prejudices that we have as a community about what mental illness and what mental illness means and whether or not people are dangerous because they're mental ill. But if we thought somebody was crazy, we would put them in this system to evaluate their competency and then restore their competency and forget about them traditionally. People would literally spend weeks or months, or even in the worst possible cases, more than a year, kind of lost in this never land where nobody really knew, are they getting evaluated? If so, what are the results of the evaluation? If they aren't competent, can they receive outpatient restoration of competency, or do they need to go to the inpatient forensic facility, et cetera? So Competency Court is really about paying attention to the problem. And when you pay attention to the problem, you realize there are a small cross-section of people, thankfully fairly small, but nonetheless a significant cross-section of people who are never going to be competent. their mental health issues, their developmental issues, their congenital birth defects, or other issues that they may suffer from so impair their lives that they've never been competent, they're never going to be competent, and no matter how many times we cycle them through this system, we're not going to restore them to competency. And it makes no sense in their cases to even charge them in the first place, because it becomes a monumental waste of resources to evaluate and reevaluate and reevaluate. My personal record so far is a person who's had 18 incidents of being evaluated for competence in the last 20 years of their life. And that's an enormous investment of resources, really to no good end. So those people can be literally turned away from the criminal system. It makes no sense to even impose criminal charges against them. And what we have agreed to in the Competency Court, however, is to try and find solutions even for those folks, because inevitably they're going to get arrested again because of their behavior or their needs or their poverty or a combination of all of those things. And we really need to break that cycle. It's an enormous waste of police resources and community resources, jail resources, in addition to competency resources, to continue to rearrest human beings over and over again to no good end. That, after all, is the definition of insanity, to do the same thing every time expecting a different result. So that's an additional kind of intervention, if you will, that really involves the police and the district attorney's office. There is a model that we're applying in Competency Court. We're a part of what's called the sequential intercept model. This idea that there are 5 or 6 areas or periods of time in the criminal process in which we can intervene to, again, make sure we're applying the right resources to the right people for the right needs at the right time. The courts live in what's called intercept 3 of that model. And what I just talked about was really intercept 2 or even intercept 1 or intercept 0. And so as the Competency Court, we're participating in the application of this sequential intercept model in the community as a broader entity to try and, again, make sure we're only evaluating and looking at people we need to really evaluate. Other models can be, even if the charges are going to be pursued, people can be restored to competency while they continue to live in the community on bail. There are circumstances where it's appropriate to let somebody be monitored in the community, managed by pretrial services, receive mental health treatment and medications, and receive basic education to restore them to competency outside of the jail. They're still in the pipeline in the sense that they are going to be prosecuted for a charge or charges. And if they're restored to competency, that will they'll return to that process, but they don't have to be in jail or in the pipeline at Lakes. That's another path, if you will, that I call an off-ramp. That is still not the charges going away or the charges not being instituted against the person, but a way to manage their needs in a way that's safe for them and safe for the community.
Okay, so you discussed how Competency Court has addressed, delays in the competency process through effective triaging. So how does Competency Court approach resolving cases efficiently and fairly?
Well, at every step that we have the privilege, and it is a privilege to interact. I am a public servant, and all of the members of this team are public servants. And all of the persons we interact, we are servants too, in my view. It is, at the end of the day, about understanding what the challenges are in timing, for example. So for many years, Lakes Crossing and the employees of Lakes Crossing were the psychologists or psychiatrists who provided evaluations to determine whether or not a person was competent. Because of staffing limitations and resource limitations, several years ago, the Lakes staff said we can no longer do that. And so one of the crises we had is who is qualified to evaluate people, and can we get them to evaluate people in a timely manner for a cost-effective price? That involved the former public defender of the county doing a lot of work to contract with a private entity called NAFCARE that has a panel of certified, qualified, Nevada licensed professionals who can do the evaluations. So very early on, we had to do a lot of work to get people timely evaluated. It was taking months sometimes to get the 2 evaluations necessary to understand whether or not a judge could even opine as to a person's competence. Once we had the evaluations, it was taking a long time to get people from the results of that evaluation to a hearing at court. That's one reason we, in the second, brought all of the cases into one department, Department 7, the department where I worked, because I could and my staff could develop processes so that there are no delays in getting a prompt hearing about whether or not somebody's competent. Once you have the hearing, you need to have prompt procedures in place so that the results of that hearing, competent, not competent, or need more information, can result in the next steps, a third evaluation, a return to the court of origin, or transit to lakes or somewhere else. And so we very methodically at every step of the process scrubbed out the human inefficiencies and the time delays so that we can promptly get people evaluated, promptly understand what their needs are, and then promptly move them to the next step. That has taken a huge amount of work, and I give a specific call out to the jail, to the sheriff of the county and the jail staff who've been instrumental in helping us, again, get people where they need to go, get people out of the jail to alternative housing if that's appropriate, and get people from the jail to lakes. I hope that answers the question.
Absolutely. Thank you. Hi, everyone. I hope you're enjoying this episode of I'll Allow It Nevada. We're always striving to bring you valuable insights and education, not just for judicial officers, but for anyone interested in the Nevada judiciary. If you find our content helpful or intriguing, please share your experience with your friends, family, and colleagues. Your support helps us reach a broader audience and ensures that more people can benefit from our discussions. Thank you for listening and supporting I'll Allow It Nevada. And so in the context of Competency Court, what are diversion programs and treatment plans, and how do they play in the court's approach?
So diversion is perhaps an overbroad or inaccurate way of describing how we manage issues in competency court. And again, I want to take a step back, or maybe several steps back, to remark on what is an obvious truism, but sometimes needs a lot of reinforcement. And that is, mental illness is not a crime. To have a schizophrenic condition, for example, that causes you to respond to internal stimuli or make odd statements or have an odd demeanor does not make you a criminal, and really statistically does not make you more dangerous than anyone else. There is, in fact, very little social science which supports the idea that being mentally ill or having a serious mental illness is associated with danger. There are certainly mentally ill people who are dangerous, but the two are not a one-to-one correlation. And that's perhaps the place to begin is, again, we have this world where we have inadequate mental health resources. And because we have inadequate mental health resources, our first responders, police, fire, teachers, people in the community who are the first to come in contact with human beings, or particularly human beings in crisis. When our first responders are tasked with, rather than being a police officer, being a psychologist on the street to understand why is this person acting oddly, we have a system designed to capture people with mental health issues into the criminal system when they don't necessarily need to be in the criminal system. It's not to excuse bad behavior, but instead to understand what is the context of the behavior, what is the cause of the behavior. So, for example, there are a number of cases that have come to a competency court where people are urinating in public, where if you're unhoused and you literally don't have a bathroom and you live in a community that doesn't have public restrooms easily available and it's cold in the winter, these things are natural to occur. Again, I am in no way forgiving or immunizing criminal misconduct, but urinating in public is generally on the scale of a status offense, or being in the wrong place at the wrong time, or loitering after hours in an area where you may be trying to find shelter for the evening or for the day because you are unhoused. And so really, philosophically, what Competency Court is about and this sequential intercept model is about is understanding what's the risk the person represents. Is the risk principally to themselves and to the immediate people around them as opposed to the community at large? And is the appropriate management of that risk to put them in jail? Because we know unequivocally that if you put people with mental health issues, particularly seriously mentally ill people in jail, they unequivocally get worse. And particularly if they're in jail for no good reason or because of delays in an impacted system, we've now guaranteed we've made it more likely they're going to commit another crime. And at the end of the day, I'm about public safety. I'm about what is going to lead to a healthier, safer community. And again, breaking this cycle of using the police and the jail as mental health screeners and mental health providers, particularly for the unhoused community and for the community in poverty, is a setup for disaster. It is a way to have very full jails, very full prisons, and not breaking the cycle of whatever criminality people may be involved in.
Right. And just effectively helping to reduce that recidivism.
Correct.
Yeah. Okay. So maybe it's a bit evident, but maybe we can just kind of summarize what, from your point of view, how has the court impacted the broader community in Washoe County? And do you have anything you can share to kind of illustrate that?
Yes, I have two major areas to discuss. The first is a little bit obscene in the sense that dollars and cents, in my opinion, are among the least important reasons to do what we do. However, at the Board of County Commissioners last week, the Competency Court team presented the following figure to the BCC. So taking that, I think the number is about 46 people, but taking the people who were removed from jail to either be placed in a mental health hospital or into the community at alternative housing, such as the CARES campus or a group home or whatever placement we could cobble together. If you just look at the number of days those people would have spent in jail as opposed to out of jail receiving treatment, and you multiply each day that we saved the community by those people out of custody, out of the pipeline, the number between October 2023 and December 2024, December 31st, 2024, was $2.9 million.
Wow, yeah.
In jail day savings, because an average jail day bed is between $150 to more than $1,000, depending on somebody's acute mental health needs. Mm-hmm. If they're in the infirmary and receiving mental health treatment around the clock, it can be very, very expensive. And so the dollars and cents are compelling. They are millions and millions of dollars just in our little community, even with a small number of people, right? 50 to 80 people. More important than the dollars and cents, though, is this idea that the criminal justice system provide due process, that if you're accused of a crime, you only be held in custody because there's good reason based on your risk to the community, as opposed to your mental health needs. This court is not about diverting murderers, rapists, and robbers from jail. It is not about that at all. What it is about is understanding that there are a significant cross-section of people who are captured for very low-level offenses, whose needs predominate, their mental health needs predominate, not their criminogenic risk needs. It is not so much that they represent a danger to the community as it is they represent a danger to themselves, and we're making them worse by applying jail as the default setting to their needs. So really the success, in my view, and the impact in the community is to find the right service for the right person at the right time, and to build a culture of understanding what are the criminogenic risks that people have, and how do we separate the sharks from the minnows. I am not interested in having dangerous people running around the community, particularly if they're allegedly committing crimes or guilty of those crimes. I think I'm fairly well known as a tough sentencing judge when after people are convicted and accusations have been brought. But I hope I'm also well known as a judge who recognizes you can't incarcerate your way out of mental health illness. That is the exact wrong model to use to get people better and less criminal. And really, the success, I think, will continue to pay dividends in the quality of the community, the lives of the people in the community.
Right. And it's a pretty young court. And so it was established in 2023, you mentioned. So it seems like it's having already quite a profound impact. And who knows what kind of, like you said, it will pay back in dividends in the years to come as this court develops and divert more people away from the criminal justice system.
Correct.
So how does the court measure its success in achieving its goals?
Many ways. So I've mentioned jail bed days savings, decreased recidivism, decreased evaluation of people who don't need to be evaluated, or people in which we already know what the results of the evaluation will be given history, et cetera. So there's many dollar savings in multi-facets I just described. But then again, more importantly than the dollar savings is the idea that we wouldn't be jailing people for mental health issues and that they wouldn't languish in jail because we have an impacted system, that we would use the right resources at the right time in people's lives. So measurement of success involves jail bed day savings, improvement in mental health conditions, decrease in the number of arrests that people have over time. There's a famous phrase called harm reduction, the idea that if somebody has a serious mental illness, for example, longstanding schizophrenia, the goal is often, unfortunately, not a cure of their schizophrenia, but it is to keep them out of jail, in the community, consistently on their medications in ways that are safe for them and the people around them. And you can measure those things by understanding when was the last time a person was arrested. What is their medication compliance? Are they taking their meds 5 days a week, 6 days a week, 7 days a week, et cetera? So there are all sorts of different metrics of success. But ultimately, for me, it will be to see that we are not using the jail as the mental health treatment facility of choice in the county.
Right. So are there any goals you have for Competency Court that you can share with us?
Yeah, to build on the continuing success and really to be a partner for the sequential intercept model. So Competency Court is a very small part of this broader initiative in the county that the court and the county are partnering. The county by, I mean, the county, the Board of County Commissioners. But we have a very strong mental health initiative in the county to really address the mental health crisis that exists in the county. And one of my goals for Competency Court is to show in this one intercept area how targeted, thoughtful, planful interventions across all 6 intercepts will lead to exponential dividends across the county. I really do believe that in Washoe County, if we own this problem and attack this problem, we have the right resources to really move the needle to improve the quality of life in the county. And so Competency Court, to my eye, is a key, small, but a key player in that overall process. And so my big goal is mental health, improving the condition of mental health services in the county and the condition that really the health of the county from a mental health perspective.
Okay, so develop the services available and then leveraging those services to continue the mission of the court.
Correct.
Okay. So what are some lessons that you or your team have learned through, I guess, have you learned any lessons over presiding over this court?
I have. An easy lesson that I would amplify is this. Each of the defendants I deal with is a human being, and they have needs. Now, their needs may be in conflict with the needs of the society. For example, if you commit a homicide and you're in fact guilty of that homicide, not just accused of it, but there's proof beyond a reasonable doubt or you admit to it, you represent a risk to the community and a danger arguably to the community and perhaps to yourself. But you are still a human being and you still are entitled to the protections of the Constitution. That's one end of the spectrum. The other end of the spectrum is I am privileged now to meet a lot of people who end up getting arrested a lot who aren't particularly criminal. It's not to say that they don't on occasion commit crimes like petty larceny or trespassing or things of that nature. But unequivocally, if my goal is to intervene with them so that they don't commit those crimes, I first have to demonstrate to them that I care about them enough to understand what is happening to them in the process. This idea of due process has meaning. It's the idea that we treat people fairly and appropriately when they're captured in the system. And what's been magical to me is when I see the defendants understand that we actually care about them getting better, they get better.
Yeah, that's amazing. Yes, that's a different perspective for a judge, I guess, seeing that, especially when you're seeing offenders multiple times for these types of offenses, and you kind of realize these aren't particularly criminal people.
Yes. And my goal is that they commit fewer crimes, right? And if I want them to commit fewer crimes, I have to help them get better. Right. And once they figure out that we care enough, they are motivated to get better, overwhelmingly. There are always exceptions, right? And there are certainly some dangerous people who need to be segregated from the community. I don't want anybody to mistake as they listen to this, the idea that, oh, this is some soft-hearted liberal judge who wants to let everybody out of jail. That is not what I'm suggesting.
Right.
What I am suggesting is the right resource for the right risks and needs at the right time.
Right. All right. Well, before we wrap up this conversation, is there anything else you would like to share with our audience about your court?
Only that it is such a great privilege to serve the community in the role in which I do as a judge. I'm deeply and profoundly thankful for that opportunity. And I welcome anyone who's interested in this topic to come see Competency Court. It's a public proceeding every Thursday at 4. The public is welcome. You're welcome to come see the resources we're trying to apply and the tools we're trying to apply to a very broad-based community health problem, which is the mental health crisis that we have in our community.
How often do you hold Competency Court? It's on Thursdays, correct?
Every Thursday.
Every Thursday.
It is.
Okay, excellent. Well, Judge Walker, thank you not only for joining me on the show. It's been great featuring your expertise and your insights to Competency Court, but also thanks for everything you do to improve the community and the lives of those living in Washoe County. It's greatly appreciated. And thanks again for speaking with me.
I appreciate your kind words. Thank you very much for the opportunity to appear. Happy to appear anytime, Seth.
Thank you. A heartfelt appreciation to our guest and to everyone who has tuned in to this episode. Before we wrap up, here are a couple of quick important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. If you have any questions, topic suggestions, or comments, we welcome your input. Please email them to jepodcast@nvcourts.nv.gov. We value and look forward to hearing from our listeners. Stay tuned for more episodes of I'll Allow It Nevada. This is Seth Easley signing off. Take care, Nevada.